Dear students, welcome to this class. So the chapter we are going through is immunity under international law. So the purpose for this chapter is for you to understand the legal protections granted to states, diplomats, and certain officials from the jurisdiction of foreign courts in order to uphold sovereign equality, facilitate diplomatic relations, and maintain international legal order. So these are the objectives for this chapter. So international law recognizes instances where there are restrictions on the extent to which legal suits may be brought against a foreign state, a national of foreign state, or an employee of an international organization. And in these three instances, international law recognizes certain forms of immunity. So, in cases where a legal suit against a foreign state is prohibited from being brought in the domestic courts of another state, this is known as state immunity. And in instances where legal suits may not be brought against certain employees of certain organizations, this is known as organizational immunity. So let us look at state immunity in details. So the doctrine of foreign immunity provides that a foreign state generally is immune from the jurisdiction of the courts of another sovereign state. And state immunity developed as an distributed principle of customary international law and the law of nations based upon core aspects of sovereign applicable in common law, civil law, and other judicial systems. So, historically, the head of a state or a sovereign was associated with the state, and originally, both of them enjoyed under customary international law absolute immunity in all areas of their activities from the jurisdiction of another state. But while the head of a state continues to date enjoy such absolute immunity, even for his private activities, a state nowadays enjoys only qualified or what we call a restrictive immunity. And under the qualified or restrictive immunity, a state enjoys immunity only in respect of its governmental acts, not in respect of its commercial acts. So let us look at the levels in which sovereign immunity arises. So there is a first level which concerns the immunity of a state from the jurisdiction of courts of another state, and that is courts of a state cannot adjudicate a claim against foreign state. So in the second level, this concerns the immunity of a state from the execution of enforcement measures undertaken by courts of another state. So there are also two kinds of state immunity, that is absolute immunity, where these are sovereign acts or acts of a state. There is also range of sovereign acts, and these are acts like government functions such as defense, taxation, and among others. So let us look at diplomatic immunity. So diplomatic immunity differs from the state immunity in the sense that while the state immunity attaches to a foreign state and its agents, diplomatic immunity attaches to a foreign diplomatic mission, for example, an embassy and high commission. So and also its agents. So a diplomatic immunity, unlike state immunity, is governed by two treaties, and these are the Vienna Convention on Diplomatic Relations that was signed in 1964, and the Vienna Convention on Consular Relations, and that was also signed in 1964. So in addition, the rules relating to diplomatic immunities and relations are regarded as having acquired the status of customary international law since they have been the subject of state practice over several centuries. So let us have just a brief of the Vienna Convention on Diplomatic Relations in 1961. So this treaty, which came into force in 1964, as we have seen in the previous slide, emphasizes the the functional necessity of diplomatic privileges and immunities for the efficient conduct of international relations, as well as pointing to the character of the diplomatic mission as representing its both codified existing laws and established others. So questions not expressly regulated by the convention continue to be governed by the rules of customary international law. Let us also look at consular immunity. This is drawn from Vienna in 1963, Article 43. So this states that immune from an arrest or detention pending trial, except in the case of a grave crime and pursuant to a decision by the competent judicial authority. He is immune from imprisonment or any other restriction on his personal freedom, save in execution of final judicial decision. So, if a criminal proceedings are instituted against him, he must appear before the competent authorities. So the second was immune from the jurisdiction of the judicial or administrative authorities of the receiving state only in respect of acts performed in exercise of consular functions. However, they do not enjoy such immunity in respect of a civil action, either arising out of a contract concluded by them, not as agents of the sending state, or brought by third party for damages arising from an accident in the receiving state caused by vehicle, vessels, or aircraft. Thirdly, exempt from all dues and taxes except on certain specified cases, he is also entitled to decline to give evidence as expert witness with regard to the law of the sending state. Fourthly, a member of the consular post enjoys the freedom of communication for official purposes. And the fifth was a member of the consular post enjoys the right to move freely in the territory of the receiving state. And the sixth, the archives, documents, official correspondence, and consular bag are inviolable at any time and whenever they may be. And lastly, the premises of the consular post and the private residences of members of the consular post are also inviolable. They are also exempt from all taxes and dues other than such as a present payment for specific services. So let us look at absolute and restricted immunity. So in the previous slides, we have seen how the doctrine of state immunity has evolved through different approaches. But the earliest articulation of the doctrine was that absolute immunity, which was the idea that under no circumstance could any kind of legal suit be brought against foreign state, regardless of the action. So the absolute immunity concept, however, came under criticism because it was regarded as allowing foreign states to act with impunity even when there was no justification in terms of acts of the state. So beginning in the early 20th century, therefore, Western nations adopted a more restrictive approach to immunity in response to the fact that foreign states were engaging more and more in trade and economic affairs. So let us look at waiver of immunity. So by Article 32 of the 1961 Vienna Convention, the sending state may waive the immunity from jurisdiction of diplomatic agents and others possessing immunity under the convention. So such a waiver must be expressed. That was the condition where a person with immunity initiates proceedings. He cannot claim immunity in respect of any counterclaim directly connected with the principal claim. So, waiver of immunity from jurisdiction in respect of civil or administrative proceedings is not to be taken to imply waiver from immunity in respect of the execution of the judgment for which a separate waiver is necessary. I have attached the reading materials for this chapter in case you want to read more, understand more or about this chapter. Please go ahead and use these materials. That's all for now. Thank you.